Major breaking news out of the United States Supreme Court. The Supreme Court has decided to hear a case that will specifically address whether or not the so-called Chevron doctrine is still the law of the land. This is something we've been trying to get rid of, specifically in connection with ATF regulatory authority for literally decades. Wait to hear what's about to happen, and it's going to happen. Trust me, folks. We'll talk in a minute. Hey folks, I'm Mark Smith, host of the 4 Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new Second Amendment book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms, now available for sale on Amazon. We'll talk about that book more down the road. But for today, we're going to talk about the United States Supreme Court. That's right, folks, big deal out of Washington. The Supreme Court just this morning granted certiorari in a case called Loper Bright Enterprises versus Raimondo. This is a direct frontal challenge to the so-called Chevron doctrine. Now, the Chevron doctrine is something we've talked about before. This is a very big deal. Back in the 1980s, the United States Supreme Court, wrongly in my opinion, came out and said that if there is some sort of ambiguity or question or gap in congressional statutes giving authority or powers to regulatory agencies such as the ATF, the FDA, the EPA dealing with environmental issues and the like, then the agencies get to dictate and decide for themselves and for the country what the law means and whether or not the regulations they promulgate are lawful or not. And if there's any doubt whatsoever under the Chevron doctrine, courts reviewing the authority of these agencies have to defer to the agency's interpretation and application of the congressional statutes that allow them to regulate various parts of the American world, of the American economy, the American gun industry, and the like. Now, this is a terrible doctrine, the Chevron doctrine, because it basically gives unelected bureaucrats huge power to legislate as bureaucrats without having politicians vote on specific things. This is how we got, for example, the bump stock ban. There was no act by Congress passing legislation that banned bump stocks. That never occurred. Instead, after the Las Vegas shooting, and wrongly so for a whole host of reasons we don't need to get into right now, the ATF said that a bump stock was somehow a machine gun and promulgated regulations and interpretations that said bump stocks, contrary to prior views, by the way, were indeed machine guns. Now, under the Chevron doctrine, generally speaking, the deference or the courts would defer historically to this kind of interpretation and understanding of the authority of the ATF as a general matter. Now, this gave too much power to the deep state, to regulatory agencies, to unelected bureaucrats. Basically, what it did is the Chevron doctrine is the legal foundation of the Barack Obama statement, I have a pen and a phone, and therefore I can still legislate even without Congress. Now, of course, this is something we in the gun community absolutely hate for a whole host of reasons. In the context of the ATF, of course, they promulgate all sorts of nutty things, such as regulations dealing with bump stocks, the pistol brace rules, and so on and so on. These things historically would be given deference because they are the quote-unquote experts in guns, and therefore courts should defer to the subject matter experts. And that was how it generally worked under Chevron. But the Supreme Court has just granted cert, and here is the question presented. You're going to love this. This is exactly what the Supreme Court's going to decide, and we're going to talk about the case involving fishing rights in a second. But here is the question presented that the court has granted cert on, and we'll hear, quote, whether the Supreme Court should overrule Chevron, or at least clarify that statutory silence concerning controversial powers expressly but narrowly granted elsewhere in the statute does not constitute an ambiguity requiring deference to the agency. So the key words that you need to glom onto or focus on is, should the court overrule Chevron and the notion of ambiguities requiring deference to the agency. Now, in this particular case of Loper Bright, this deals with a fishing regulation involving fishing vessels under a particular statute, which I'm not going to bore you with. But the reason why this is so hugely important is because the Supreme Court is well aware that there's a whole host of ATF cases coming before them, including the bump stock cases. Now, the court this is clear. Again, unless there's some dramatic change, the Chevron doctrine is going to be overruled and tossed into the trash bin of history in the next 12 months. Okay? Here's why I say that. As you know, there are 9 justices on the Supreme Court, one of whom has recused themselves from this case, and that is Judge Brown Jackson, who presided over this case when she was on the D.C. Court of Appeals. So she is recusing herself, which means you only have 8 justices involved in this case. And nevertheless, usually if you only have 8 justices, there's a very good chance they won't grant cert unless it's such a clear case. Well, obviously, the 8 justices on the Supreme Court view this as such a clear case, and the outcome is clear. It's not going to be like 4-4 or 5-4, anything close, because if it were going to be close, they would have taken another case to deal with the Chevron doctrine, but they clearly picked this one, and Brown Jackson's not going to be involved because she's recused herself. So this is going to be probably a 6-2 victory against the deep state, against the ATF, against the EPA, against the FDA, against, again, the bureaucracy in Washington, D.C. And that is almost certainly going to occur because there's no other reason to grant cert on the question of whether or not the court should overrule Chevron if they don't intend to do so. And this is something they've been talking about and nibbling around the edges for several years now. And we've just been waiting for that moment in time where they're going to come out with a big sledgehammer and go boom and kill it once and for all. And that is clearly what's about to happen in the next, again, 12 to 14 months. This is a very big deal because all the agencies are going to suffer dramatic reductions in their power. So when the ATF writes one of their stupid letters out the door to an FFL about our interpretation of this blah, blah, blah regulation involving the bound books or whatever it is. And then, of course, they always, if you know, they're going to cite the Chevron in those silly letters that they write out harassing FFLs and other people with their regulations. That is going to go by the wayside because it's no longer going to be the law of the land. Now, I want to say one little thing for you legal geeks out there. There is an argument in certain contexts dealing with the ATF specifically that the Chevron doctrine does not apply because they're interpreting criminal statutes with criminal penalties, and therefore the rule of lenity applies and not the Chevron doctrine. That is absolutely theoretically true, but in the real world, these things get blended together, and there's this tremendous deference from courts toward these agencies, which should never occur. Because remember, the whole point of Article 3 courts, the federal courts, is their job is to interpret and apply the law. It is not their job to defer, which is what goes on under the Chevron doctrine. They defer and let administrative agencies such as the ATF dictate the law and interpret the law. That's not how it's supposed to work. The executive branch agencies such as the ATF and the EPA, they are supposed to take the law given to them by Congress and or by Congress as interpreted by the courts and apply it. They're not supposed to be making up the law and legislating through bureaucracy and through a pen and a phone, which is what's been going on literally since the 1980s. And it's about time that this gets nipped in the bud and is ended. It is about time, and you should be very happy as to what I think this means for the bump stock cases. I think this is very good news. The only question I have is, will the Supreme Court take all those ATF-related cases before them and put them on hold on a table and hold them in abeyance while they decide this case of Loper Bright and then basically GVR those cases, which means you grant cert, vacate, and remand for further consideration in light of what's about to occur in the next 12 to 14 months? Or will they take a series of these cases, including the bump stock cases, and decide them in light of this and decide a series of these regulatory cases together? I don't know which way they're going to go. I could see them going either way. But no matter what happens, this is hugely good news for freedom, for gun owners, for the Second Amendment, for people in the gun industry, and of course, remember, for hunters. And you're like, hey, Mark, hunters. Yes, that's right. One of the videos I need to do is there's an attack on hunting on federal lands that I need to discuss where the Biden administration is trying to use things like the Chevron doctrine to basically prevent certain types of hunting on federal lands and the like. in the name of regulations. In other words, they're not trying to get Congress to pass a law. They're trying to do it through regulations in the name of the environment. And of course, they're using the Chevron doctrine to harass and make it harder to hunt on federal lands and beyond. But we'll do a separate video on that in the near future. So, okay, folks, I hope you learned a little bit something here today at the Four Boxes Diner. Make sure you check out my new book, Disarmed, about the Second Amendment and what we can learn from Ukraine. There's a lot. We'll do videos on this in the near future. And again, if you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.